Ladies and gentlemen, gentlemen and ladies, ladies and gents, this case is actually going to be interesting. So this is Crooked County, Illinois, and this is a case that was decided on June 26, 2006. Okay, but I want you to see what goes on here. Apparently, USA Bank, acting as trustee for this so-called pooling and servicing, they decided that Mr. Anthony B. Phillips did not have a right to his property. Now, Anthony had listened to other people on videos. And see, what Anthony did is Anthony decided the original lawsuit he wasn't going to respond to. So he defaulted in that original lawsuit. Now, apparently, Anthony did what was called a bonded bill of exchange. Okay, saying it was an obligation of the United States Treasury arising out of one, a consideration for pledge, and by redemption of pledge under, now he used HJR 192. Ladies and gentlemen, it's not HJR 192. Don't even focus on HJR 192. Use the March 9, 1933 Act and the notes from Congress stating that your mortgage is an obligation of the United States. Now, here's the reason why you want to do that. Now, again, there was a notice of sale. The defendant didn't respond, and he did respond by putting in a motion to vacate, and he asked them to vacate it with prejudice. Of course, they ignored him, denied it. He said that he was using Article 3, Section 603 of the Uniform Commercial Code, saying that they had not responded to his bill of exchange. They did not tender payment, and thus they defaulted, meaning the bank. The court said, hold on there, Sonny. You can't do it that way. That ain't the way we do things up here in Crooked County. Okay, the circuit court entered a judgment approving the sale and directing the sheriff of Crooked County to evict the defendant of the subject property. Now, on April 13, 2005, he filed a petition to vacate the judgment, saying the judgment was void and a collateral attack under the authority of Illinois statute. Now, he claimed that the judgment against him was void, that he had tendered payment, therefore discharging his obligation to pay the mortgage. The court denied the petition. Defendant thus filed the appeal. Now, let me explain, y'all, before we talk about what they did in their denial. Let me explain to you what you're going to be doing. Ladies and gentlemen, you need to understand the law. This individual didn't have all the laws or the facts when he put in his petition. Go back to the Credit River case. Go back to the testimony. Don't worry about whether Credit River is this or Credit River is that, or whether you can use it in your state or not. The testimony by the representative in that Credit River case. Remember, the testimony was by a employee of the Federal Reserve and the Federal Reserve Bank. Go back and look at it. Read the judge's memorandum. He said in law they're considered one and the same. And so the Federal Reserve has testified that they do not lend money. They only lend bookkeeping entry credit. Ladies and gentlemen, that's a violation of the Truth in Lending Act, because they never told you that they were lending you bookkeeping entry credit. You're just now finding out about it, and if they want to know, you'll refer them to this video, saying that you found out about it by listening to this video talk about this particular case that happened in 2006, but you're finding out about it now, and that the, pay attention, statute of limitation does not commence to run until the last overt act has been accomplished, or when you become aware of the situation, when you are notified. Well, you're just now finding out that the bank is lending credit, bookkeeping entry credit, and not monies. They are not authorized in law to lend bookkeeping entry credits without detailing this in obvious and conspicuous language in your original agreement. Go back and look. Does it ever tell you, oh, we're going to be lending you our own personal bookkeeping entry credit like a loan shark does? And based upon our credit, you're going to pay us back in US dollars. So that's going to be our exchange. There's no consideration because their credit does not exist in law. There is no law allowing them to do that. Now, let's continue. That's one of the arguments that you bring, but pay attention to what you're going to bring now, because guess what they did in Illinois? They used a California appellate court decision in Illinois Circuit Court of Appeals. Okay? Y'all need to pay attention to this because this is going to get y'all some understanding. Although we have found no Illinois cases dealing with the issue presented in this appeal, we do find a California appellate court decision which is not applicable in Illinois because this is on the appellate level for the state of California, not on the federal level. But hold on. Recent decision in McElroy versus Chase Manhattan Mortgage Company. And this case was 2005. Instructive. See, they're saying they're using this as instructions. In McElroy, the plaintiff defaulted on a loan secured by a deed on his property and attempted to redeem the loan by tendering to the defendant a bonded bill of exchange bill that is virtually identical to the bill at issue on this appeal. In this appeal. Let's continue. McElroy. Let's continue. Attached to the bill were instructions, which needs to be, stating that the bill was a negotiable instrument that could be processed by mailing it to the United States Department of the Treasury, and that the plaintiff had established a personal Uniform Commercial Code contract trust account with the Treasury Department. A personal UCC contract trust account. That's interesting. I don't know about that. I think y'all should be doing some research on that. Now pay attention. The bill expressly stated that the Secretary's obligation to honor the bill arose out of want of consideration for pledge and by redemption of the pledge under Public Resolution HJR 192. No. Pay attention. Under the March 9, 1933 Act. Now, want y'all to pay attention. The defendant refused to process the bill and subsequently sold the plaintiff property at foreclosure. No, they didn't, because they never sent a letter saying they refused to process the bill. They never indicated that they refused to process the bill. They dishonored by not responding. They had to respond in order to rebut the presumption presented to them, and they did not rebut it. On review, the court found that the bill was not a negotiable instrument because it was not made payable to the order or to the bearer as required by the California Uniform Commercial Code. So your bill has to have payable to the order of. Them hour style money orders say payable to the order or pay to the order. Pay hold on now. And it was not a check because it was not drawn on a bank. Ladies and gentlemen, checks have to be drawn on a bank and they must be backed by funds on account. So you don't ever want to make it a check. The law does not require it to be a check. Go and check the Uniform Commercial Code for the state of California. It can be a money order. The court further found that although the bill purported to identify the source of the Secretary's obligation to honor the bill, it cited no sources. The cited sources did not establish such an obligation. That's why you use the March 9, 1933 Act in the notes of Congress saying that all property is owned by the United States and the money shall be backed by the credit of the nation, because it is represents a mortgage on all the homes, all the people, all the property of all the people, all the nation. Therefore, the court concluded that the bill was a worthless piece of paper that amounted to no tender at all and found that the foreclosure was proper. Okay, ladies and gentlemen, remember, it must say payable to the order of. Even your bonds that are being created has to say payable to the order of. Just letting you know. In this case, the bill tendered by the defendant was not a negotiable instrument because it was not made payable to the bearer or order. Ladies and gentlemen, it has to have that in order to be a negotiable instrument. As required by Section 1-304, the court is telling you this. You have to be able to read this to understand what it's saying. Now pay attention. Additionally, although a check may be a negotiable instrument even when not made payable to the bearer to the order, a bill is not a check because it is not drawn on a bank. So it doesn't need to be a check. There is no law requiring it to be a check. So a bill of exchange is not a check. They just told you that. So you document in your instructions that this is not a check, not equated to a check, not supposed to be a check. Okay? We have also reviewed the sources identified in the bill as giving rise to the Secretary's obligation honor bill and found that they create no such obligation, nor do they discuss a personal treasury UCC contract trust account, really, or the redemption of a pledge. Interesting. Ladies and gentlemen, you want to do redemption of a pledge, then you have to go to government obligations. Just put in the government obligations laws. The bill is nothing more than words strung together on a piece of paper which lack any cohesive meaning and convey nothing. Under these circumstances, we find no error in the trial court refusal to acknowledge the defendant's bill as a valid negotiable instrument. In researching this conclusion, we reject the defendant's reliance on Section 6-603 of the Code, the Uniform Commercial Code, to argue that the court lacked jurisdiction to approve the sale because he had tendered payment. Remember, you must tender payment. You must tender payment to the plaintiff and was thus relieved of his obligation under the mortgage. We discussed above, the defendant did not tender payment, but rather a piece of paper that was entirely lacking in value. So how do you equate value to that bill of exchange? You associate the government's obligation. That's what gives it value. Go back and listen to the videos that I did talking about the bankruptcy and the March 9, 1933 Act. People, that's where your remedy is, and the court is telling you that. Therefore, the bill does not discharge the defendant's obligation to pay the mortgage. The circuit court did not err in approving the judicial sale of the property. Oh, and by the way, you also say they lack jurisdiction. In the first instance, this is an obligation to the United States. The property belongs to the United States, not to the bank. And the bank needs to have the authority of the United States in order to sell the property. Why? Because the ownership of all property is in a state. Individual so-called ownership is only by virtue of government. Okay? Individual so-called ownership is only by virtue of government. So it belongs to the government, and they cannot kick you out. They have to go through the government. All right, ladies and gentlemen, we want to thank you for joining us this day. Do want to tell you all, so that you all get the understanding, starting this week with the 3 videos that are being put up today, we will probably put up less than 10 videos a month. Then we will dwindle down to less than 5. Then we will dwindle down to less than 1. And that is by design. Told you we were decreasing, and so it's going to be a definite decrease. I need to focus on what's most important. So I do want to thank all of you who have tuned in thus far. And we will try to make the substantive videos more substantive in the future, so that if we're going to be doing less, we need to give you substance. That is going to be our aim. Give you also another clue, because many of you are not able to figure it out. At the SATCOM organization, they're going to be putting up in the newsletter information regarding loans, not loans, but lawsuits, how to file them, templates, that type of thing. They're going to direct you to that. Pay attention for that in the future. We want to thank you for joining us. Thank you for communicating with us. Thank you for talking to us. Thank you for being with us. And we're going to tell you, please, all of you, have a very good day. Goodbye, adios, sayonara, arrivederci, bon voyage, all of that other wonderful stuff. Have a good day, y'all.